Welcome to HR Proactive's Family and Medical Leave Act Awareness Training Program for Supervisors. In all organizations, employees require time off work due to serious medical conditions for themselves or a family member, or to spend time with their newborn child. What can you do to support an employee who approaches you to request this type of leave? The Family and Medical Leave Act, known as FMLA, that was passed in 1993, with revisions over the years, is one of the most prevalent and beneficial federal employment laws that covers job-protected leave for all employees in these circumstances. Employers who are covered under the Act provide qualified workers with job-protected leave for a specified period, both in serious medical situations and under certain personal circumstances, so they can help employees balance their family needs with the needs of the employer.
If group health insurance is provided by the employer, eligible employees of covered employers can take unpaid, job-protected leave for specified family and medical reasons with continuation of coverage under the same terms and conditions as if the employee had not taken leave. Not only does providing family and medical leave meet an employer's legislative requirements, but it also builds employee trust in the employer and supervisor during times of serious personal need or crisis, and contributes to a more committed workforce as a result of employer support. Therefore, it is critical that employers and supervisors are aware of this legislation and how to implement it within their organization. The objectives of this training video are for employers and supervisors to be able to identify their responsibilities under the FMLA, to also determine if an employee is eligible for the special leave, to become aware of how to administer and monitor leaves under the Act, and finally, recognize why it is important to provide this leave to qualified employees.
The FMLA was signed into law by Congress to provide qualified employees with a job-protected, unpaid leave from work for up to 12 weeks in a 12-month period. This leave may be used for the purpose of the birth of a child, including adoption and becoming a foster parent, as well as serious health conditions for either an employee or a close family member. After an FMLA leave, employees are entitled to return to the same job or a job with similar responsibilities and wages. Although employees are aware of the basic requirements of the law, they may not realize that it provides employers with various options on how to administer FMLA. That is why it is critical for all supervisors and human resources staff to understand how to comply with the FMLA and with the employer's FMLA policy. Employers need to train new and retrain seasoned supervisors so that employees receive the full and correct benefit of the law. In order to promote more equitable opportunity and access for all employees, the Act was amended in 2015 to include the Final Rule Law, which now provides eligibility for all legally married same-sex partners and common law partners. More information about this update to the Act can be found on the Department of Labor website.
You may be wondering which employers are covered under the Act. Those covered include private sector employers with a minimum of 50 employees for at least 20 work weeks in the current or preceding calendar year and whose employees must work within a 75-mile radius of each other. Public agencies, including local, state, and federal employers, and all local public schools are also covered under the Act. When administering the FMLA, it is important to be aware of some state-specific guidelines regarding qualifying thresholds for employees, and the employer should follow the law that is most beneficial to the employee. For example, private sector employers with less than 50 employees are not covered under the Act. However, there may be state-specific guidelines that allow employees to take family and medical leave. States that have specific guidelines for family and medical leave include California, Connecticut, Hawaii, Maine, Minnesota, New Jersey, Oregon, Rhode Island, Vermont, Washington, Wisconsin, and District of Columbia. If your state is on this list, please follow the more expansive FMLA standards. It is important that you check the legislation, both for your state or district, and with the Department of Labor frequently, as laws can change.
As an employer or supervisor, it is your responsibility to inform employees under your supervision that they are required to work for a minimum of 12 months in total for your organization. Those 12 months do not need to be consecutive. For example, if an employee normally works for a seasonal employer from May to September within a 12-month period and returns the following year, they may be eligible for an FMLA leave. Another example would be special eligibility requirements under the Act for airline flight attendants and crew members due to their non-traditional work schedules. If you receive an employee leave request with unique criteria, please refer to the Employee Guidelines document included with this video program. The guidelines provide information about how to apply special eligibility requirements under the FMLA.
As well, an employee must have logged at least 1,250 hours of work during the last year. The hours also need to be worked in the consecutive month, not sporadically over a 12-month period. As a rule of thumb, 1,250 hours equates to approximately 24 hours of work per week over a 12-month period. If someone were working a shorter number of months, they would need to be working more than 24 hours per week to meet this criterion. Employees who meet the criteria can take family and medical leave for themselves or their eligible spouse, parents, and/or children. The Supervisor fact sheet with this video program provides definitions of eligible spouse, parents, and children.
Providing an employee meets the previously outlined eligibility requirements for the FMLA, he or she can take up to 12 unpaid work weeks of leave in a 12-month period for the following reasons: the birth of a child, to care for a spouse, child, or parent who has a serious health condition, and if the employee themselves is unable to perform the essential duties of his or her job due to a serious health condition. You can request medical certification from a healthcare provider for clarification of a serious illness. The request should be made within 5 days of the employee's initial request, and employees are required to provide the employer with a medical certificate within 15 days. If the employee wants to continue to receive wages during the FMLA leave, he or she can make a request to use sick, vacation, or personal time. You may also ask an employee to use a portion of their vacation time along with the FMLA leave, such as during the recovery period after they have had surgery.
Let's take a look at Robert, who has been working at your company for the past 3 years as a seasonal worker. In January, Robert approaches you to request an FMLA leave to care for his ailing mother, who is entering the hospital for surgery next month. He wants to be sure to give you the required 30-day notice for his leave request. And when she returns home, Robert's mother will be unable to care for herself. He asks for 2 weeks of leave to care for his mother while she recuperates. What is your next step with Robert? First, you want to check Robert's employment record to confirm that he has met the 12 months and 1,250-hour criteria for the FMLA leave. You will also want to confirm if there are any state laws that might have other information for you to consider regarding Robert's request for personal leave. Once you confirm that information, you will want Human Resources to obtain a medical certificate from his mother's physician to confirm her surgery and recuperation dates. Considering all of this information, and as long as Robert has worked 1,250 hours in consecutive months this year, you can provide him with the unpaid FMLA leave. It is unlikely that Robert would have accumulated vacation time that he can use. You can consider how to deploy your team differently during the 2 weeks Robert is off work. If you have casual workers that you regularly call on during extremely busy times, you could ask them to assist as necessary when Robert is away. Remember, the FMLA is a job-protected leave, and you cannot replace Robert unless you have an equivalent position for him, with equivalent work and the same wages after he returns from his leave.
In 2008, the FMLA was amended to provide employees with family members serving in the armed forces, National Guard, and reserves with FMLA leave for reasons related to their family members' military service. In 2010, the FMLA was again amended, expanding the military-related leave protections and to include a special eligibility provision for airline flight crew employees. The FMLA also mandates that employees can take up to 12 unpaid work weeks of leave in a 12-month period for any qualifying exigency for military family leave arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on active duty, and up to 26 work weeks of leave in a 12-month period can be taken for military caregiver leave.
Employers have several responsibilities under the FMLA, one of which includes providing general notice of the FMLA guidelines on a workplace poster and informing all individual staff. Let us consider the following scenario to understand other responsibilities. In the 10 years that Lisa has worked for your organization, she has never abused the sick leave policy. She has come to you requesting time off to attend to a serious medical condition. She is concerned that if she does take this needed time, that she may lose her job. As the employer, what do you need to do to respond to her request? What is your response about her concern regarding her job security with the organization? Answer. As the employer, you would need to inform her within 5 days as to whether she is eligible for FMLA leave upon receiving the medical documentation from Lisa. She must submit the medical certification to you within 15 calendar days, and she will need to pay the cost of obtaining that certification. In this scenario, Lisa's medical information indicated that she has stage 3 breast cancer and requires time off for surgery and follow-up treatments. If this situation was not a serious medical condition and Lisa was not eligible for FMLA leave, then, as the employer, you would need to provide at least one reason for the ineligibility.
Take a moment to reflect on what that reason might be. Yes, one reason may be insufficient medical documentation, and also could be that Lisa did not meet her employee obligations around timelines, etc. Lisa does not need to worry about losing her position because, as the employer, you are required to hold Lisa's position until she returns from FMLA leave. If that is not possible, then you will need to provide an equivalent position with the same wages, benefits, and responsibility as she held in her previous position. Keep in mind that all benefits she had before her leave, she has upon her return to work, including the accrual of sick and vacation time. It is important to be most supportive of Lisa and ensure that there is not any retaliation as a result of her medical leave. By doing so, you are building a culture of support and establishing a workplace that cares about all the needs of employees.
Records and documents relating to medical certifications, recertifications, or medical histories of employees or employees' family members created for purposes of FMLA are required to be maintained as confidential medical records in separate files and/or records from the usual personnel files. Lisa's FMLA medical file must be filed separately in your Human Resources Department and only disclosed on a need-to-know basis. When medical certification is required to support the application for FMLA leave, there are very specific guidelines you must follow as you work with your Human Resource Department. In the situation, Lisa may return to work after her initial leave and need to seek further FMLA leave a year or more later, in which case she will need to produce medical certification each time. Once again, you will be required to notify Lisa if she is eligible within 5 business days, and the notice must be included in the written notice of FMLA rights and responsibilities given to Lisa when the leave is first requested. If Lisa did not provide complete certification, it could result in her FMLA leave being denied.
It is important to note that you may request additional medical certification in certain circumstances, such as not receiving complete and sufficient certification and/or have reason to doubt its validity. You are also entitled to request a second and third opinion at a later date if there is a concern or a question about the appropriateness of the leave or its duration. However, in this situation, you would be responsible for the cost of these opinions, keeping in mind that they may only be requested after 30 days of receiving the medical certification on file. If you are interested in obtaining additional information regarding medical certification, check the U.S. Department of Labor website.
To benefit all employees, it is important that you be open, engaging, and consistent in your communication about the Act, and follow the employer and employee rights and responsibilities. The FMLA supports a healthier and happier employee and workplace environment as it provides individuals with the opportunity to take care of themselves or their loved ones without fear of losing their job. It reflects the fair and strong commitment of management to care for the personal needs of an employee and benefits the organization through employee satisfaction and retention. Remember, if in doubt, check the legislation for clarification and any other legislation that may be applicable.
This concludes the FMLA Awareness Training video. Now it's time to test your knowledge of the Family and Medical Leave Act, FMLA, by answering the following 10 questions. Upon successful completion, you will receive your FMLA Awareness Certificate of Completion.